Hi, my name's Tyler Jensen.
Hi, my name is Miles Lebaron.
Hello, my name is Dallin Morrow. I am a personal injury attorney at Lebaron&Jensen.
We help people with car accidents, and today we want to talk about some of the different terms that we use every day in the car accident and personal injury world, but that you may not understand. Liability is a word that we use often in the personal injury world, and what it means is that somebody is responsible for the harm that they caused.
Our next word is negligence, and I think in plain English I would say negligence is you screwed up. And so common examples of screwing up in my world are if you rear end someone, in most cases, you were negligent.
Plaintiff. A plaintiff is someone who sues someone else. So in your case, if we have to file a lawsuit against the person who injured you, you would be called the plaintiff in that lawsuit.
A defendant is the person who has caused the harm, and we're seeking to go after the defendant's insurance policy to help satisfy our client, the plaintiff, their harm.
Our next word is complaint. And a complaint is not just complaining about something. In the law, a complaint is a legal document where you set forth as the plaintiff how the defendant has wronged you and how you're entitled to money damages.
Litigation is another word for a lawsuit. So anything that happens associated with a lawsuit after the lawsuit has been filed is called litigation. That could include a trial, that could include depositions. Any of that falls under the label of litigation.
When we talk about what discovery is, it's really a term of art. It refers to the beginning part of the lawsuit or the litigation. Usually it involves written questions or requests for documents or for somebody to admit something. It can also include taking the testimony of a witness or somebody who is involved in the accident.
And deposition is just a fancy word for where one attorney will ask questions of a witness, and if the witness is a party, meaning that they're a plaintiff or a defendant in the case, then that party's attorney would show up and object to any improper questioning. If they're not a party, sometimes they'll still have their attorney show up and object to any improper questioning. But a deposition is really where you're just asking questions, and the deponent, the person having their deposition taken, is answering those questions under oath as if they were in court. And then what you can do with the deposition transcript is use that in court as their testimony. And sometimes you don't even have, like if that person isn't available for trial, then you could actually have someone that you just have come in and say, this is what they read. So they would show up on the stand and read, can you read what they said at paragraph blah, blah, blah. And so that's how a deposition can be used in a trial setting.
A motion is basically a request to the judge to do something. So if you've ever heard in conversational English that a case got thrown out or someone's asking the judge to throw out a case, in the legal world, what we do is we file a motion to dismiss.
A judgment occurs at the very end of the case. The judgment will typically be the amount of money that the plaintiff is entitled to, or if the defendant wins, it's the terms by which the court found that that person was not at fault.
Next phrase, not word, but the next phrase is statute of limitations. And that's a big fancy legal term for basically saying, hey, you've got so long to bring your claim. So in the personal injury world, The statute of limitations for negligence, when somebody screws up, is typically 4 years in a lot of states. Now, state of Utah, for instance, it's a 4-year statute of limitations. So you have 4 years from the date that somebody screwed up to bring your claim against that person who screwed up. And if you miss that, then, you know, there's another, so sometimes you see statute of limitations being SOL. Well, you might have heard of SOL being used for a different phrase, and you are SOL if you miss the statute of limitations.
A claim means that you have the right to go to court and file a lawsuit and sue someone to recover for what's happened to you. That's what we call a claim.
Damages is another term of art. What that means in the context of a personal injury case is the amount of money that the insurance company or their insured owes you because of the car accident.
Settlement. Settlement is just a big term for when the parties agree on something. And in our world, in personal injury, usually when you settle, what you're talking about is somebody giving somebody else money. And in most cases, that means that the insurance company is paying X amount of dollars for our client to go away and not pursue them anymore, or pursue their insured anymore. And so settlement is where the parties get together and agree on a number that they can live with. Usually it's not great for either side. Usually a good settlement is one that nobody really loves, but that they can live with.
If you've ever seen a commercial that says you may be entitled to compensation, what they're talking about with compensation is payment of your medical bills, payment for future medical bills that you're going to need as a result of your injuries, and also some money that you get for the pain and suffering that you've been through.
Pain and suffering is a term that means damages that are not financial in nature. So a financial damage would be like lost work. Pain and suffering are those damages where they're difficult to quantify. They would include you being so injured that you can't sleep at night, or you have a trip to Europe on the books and you aren't able to go because you were involved in a car accident. Those damages are referred to as pain and suffering damages.
Lost wages. Lost wages is, I used to be able to work and now I can't work. Or I used to be able to work full-time and now I can't work full-time. And so if you miss work, whether that's a week, a month, or I'm permanently injured and I can't work for the rest of my life, then what we do is we get a lost wages calculation. And sometimes that can be as simple as, hey, our client couldn't work for 2 weeks. Here's their hourly wage times 40 hours. That's their lost wages. And sometimes you really have to get an economic expert and do this whole big economic calculation. And they do all the math and crunch all the numbers and come up with a calculation as to what lost wages are.
An insurance adjuster is a person that works for the insurance company, and their job is to investigate and value your claim. And they'll come to a decision on what they think your claim is worth and send you an offer to settle your claim.
Evidence is a pretty general term used to describe the facts of a case. So as an example, different types of evidence might be an accident reconstruction, showing how the accident actually happened. It might be video evidence from somebody's Ring doorbell showing how an accident happened. They could be written documents, expert reports. Those kinds of things are all different types of evidence.
Demand letter. So in a personal injury case, what we do typically is we try to help the client get all the treatment that they need to get better, or as close to better as they can get. what I oftentimes call as good as it gets, what medical professionals call maximum medical improvement, or MMI for short. And once you get to that point, then what we do is we gather up all of your bills and all of your records, and we put them into this letter that requires quite a bit of thought and effort and time. Usually a good demand, especially if you've had a lot of treatment, if you've seen lots of providers, will be 8 to 10 pages, and then your medical records that support that could be, 2,000 pages sometimes of medical records. And so it's a lot to go through and put together, and sometimes that process can take several days or even weeks, depending on how complicated the case is. And sometimes we have to make legal arguments in the demand. And so that demand letter is what we send out initially in hopes that we can settle the case without litigation, without filing a lawsuit. And that's a demand letter.
In personal injury claims, our law firm gets paid through a contingency fee, which means we do not get paid anything until we recover money for you. And then our fee comes out of that total amount of recovery.
I hope this video was helpful. The legal world in some ways is like speaking a different language, and so you don't understand what is being said unless you understand the words that are being used. If you have questions about different terms that we use, we would encourage you in the comment section below just to ask those specific questions, and we'll help define those terms for you. We also don't have any problem doing a second video if we come up with another list of terms that people have questions on.
If you have any more questions, please feel free to give us a call. It's free to ask. We're happy to sit down and talk with you about your situation and what's going on and see if we can help. And if you've been injured and it wasn't your fault, we can help you.